We have a lot to cover, and I want to make sure we get through it. Standard I, closing documents. It deleted the reference that the seller was to pay for the preparation of certain documents, but only because that's now covered in paragraph 9.
Are you on the other one? The one that we were just finished, or are you on the which contract are you on?
I'm just finishing the bar 2, not the as-is contract. And by the way, I'll apologize. At least one person here has said, gee, since we use the as-is all the time, it would be, can't you just go through the as-is contract and leave as a footnote the bar 2? I probably can. The challenge for me is that I sort of grew up with this whole evolution of the forms. I've been on the committee of local association council for 15 or 16 years now, and we deal with this twice a year. The history of it is that as is used to be a rider. It was a pre-printed rider, and it said which provisions of the contract were deleted and which were modified, and then added the language about the inspection period. Don't quote me on it, but I think it was 2007 when we separated them out and made the as-is a separate contract so that we eliminated possible conflicts or ambiguities when you've got a rider that modifies the main contract. So I've just kind of always thought of it in terms of as-is modifies or supplements the standard contract. I do think you need to be familiar with both of them, and particularly if you've got a circumstance where a broker or an associate from a firm that's not in the Keys presents a contract. We use the as-is contract much more prevalently here in the Keys than the practices that prevail on the mainland. And you've got to sometimes make some pretty quick decisions during the course of your practice, and you may not have your favorite advisor available. So I think there's just no substitute for taking these forms, and even though you listen carefully today and took notes and all that, study it and study it again and get to the point where you can just, off the top of your head say, here's what the form says. And it's a hard thing to do because the software leads you to each place where you have to give input. You could ignore it altogether, but it's just, you're best equipped to prevent your client, you're representing a buyer or a seller or both, you're the one best equipped to ensure that they don't come to me for anything other than to close the deal and pop the champagne. And this is what defines the agreement. So, and I'll get off my soapbox about that. Loan commitment. It now specifically provides something I hope everybody already knew. Pre-approval or pre-qualification is not a loan commitment, doesn't satisfy the requirement, can't be treated as such on either side. Now, if a buyer wants to treat it as such, the buyer runs the risk of saying the contingency has been satisfied, and therefore the buyer's obligated to sell. The buyer's obligated to buy no matter what, but probably the most important part of it is that the effect for a seller, and a seller should really just ignore it. It's, in my view, a pre-approval or pre-qualification is more of a tool for you all to be able to determine, if you're privy to that information, whether you've got a qualified buyer. Can't imagine anything less fun than working for a couple of months to put something together with somebody who was never serious in the first place or didn't have a prayer of ever pulling the transaction off. There are a number of things about Standard 5, FERPTA. It describes the parties' responsibilities with regard to the Internal Revenue Code, the 10%, that a buyer must withhold 10% unless the seller is not a foreign person, there is a withholding certificate that requires reduced or eliminated withholding, or there's an exemption claimed. Again, I don't think we encounter it often, but take a careful look at these points. And again, good idea is when you're taking a listing, just the question. You qualify as a foreign person. 10%.
No, I'm talking about the sale price of the property, isn't it? Just going to the house is over a certain amount.
If that's, because probably I don't think I've ever been involved in a transaction that was low enough. It's going to be a pretty low one. As you know, the IRS, they're pretty aggressive about collecting their taxes. Huge problem, you know, people from other countries taking the proceeds and going back home.
Wayne,
Says
if there is one, I don't know what it is.
it says,
Line 603,
Says,
$300,000 or less.
is the cutoff? There's your answer.
Thank you.
What line?
This standard takes the place of what was previously rider I. And that's why when we get to the rider, you're going to see that rider I is just marked reserved, and there is no rider I because it's now been incorporated into this standard. Yes, Michael.
Even though it does say that there is, quote, an exemption for residential property under $300,000, it does go on to say that this is a very complicated tax law, and that if this is going to be involved in the transaction, you should always have the advice of a tax attorney.
And it's why the form emphasizes that now, because I couldn't agree with it more. It's incredibly complex, and the stakes are pretty high if you have a foreign person, at least for the seller.
Wayne, would you agree that it's not a bad idea, even if you have foreign buyers, that you tell them about that, kind of like from the jump, so they don't hate you when they go to sell the property?
Sure. Yeah, although I think if you didn't do that, even if the foreign buyer was very unhappy with you several years down the road because you didn't tell him, I don't think you've got an obligation to do that. I think, generally speaking, the law would presume that a person entering into a real estate transaction either knows what they're getting into or they get legal advice.
A lot of foreign nationals are completely unaware of that for some reason.
That
that have already bought property in this country.
Yeah, they may be from a country where the practices are so different they wouldn't have any reason to expect it. I think it's a good idea, but I wouldn't, lose sleep to remember one where you didn't do it.
I told them.
Okay, 19 addenda. The name of Rider A was changed from Condo Association to Condo Rider. As I mentioned, the reference to Rider I, which was entitled FERPTA, is now marked reserved. And Rider P, dealing with lead-based paint disclosure, has been renamed. And now I'm going to go to the as-is contract. Hopefully I haven't lost you, since I know this is really important to you. But here's the simple rule. Everything we've talked about, with the exception of paragraph 12 of the standard contract, take out paragraph 12, and everything I've said applies to the as-is contract, because it's all incorporated wholesale. And now we're going to talk about what's added to the as-is, which is essentially to take the place of what's in paragraph 12. So on the as-is contract, if you want to switch to that form, again, I think using the red line as the one that you look at makes it easier to follow this. As I outline it, paragraph 10J, like Juliet, substituted the word stated in the second sentence with the word provided. The intention here was to give more clarity in a circumstance where there's verbal disclosure. My advice to you is don't ever rely on verbal disclosure if it's anything that could remotely be important. And while verbal events happen all the time, make it your practice to, at a minimum, send an email to the broker or agent on the other side to say, just writing to confirm that today during our walkthrough of the property, the seller disclosed to the buyer that. Again, when problems come up, they turn into problems that can't be easily resolved whenever there's open questions about what happened. And the simple way to resolve that is to be very meticulous about documenting. And you can document anything. If it's, I want to say, you said to me yesterday, good morning, how are you? I can say, you said this to me yesterday morning. I'm going to rely on you having said it. you didn't say that, or I misinterpreted it, let me know within 24 hours. You don't have to answer within 24 hours, but later, if you want to say you didn't say it, someone's naturally going to go, well, gosh, why didn't you speak up when you got this email? So try to document anything that's verbal, even though this clarification is added. Property inspection and the right to counsel. Follow on to a conversation we had earlier, so listen carefully. The word from has been substituted with the word after in the default clause describing when to perform inspections, and the purpose was to clarify the counting of the time period for inspection. Previously, the provision said 15 days from the effective date. It created some confusion as to when to begin calculating the time. Remember, this is the default provision. If you don't say anything at all, which I don't recommend, don't leave any blank unattended or unaddressed. But if you do, with regard to the inspection period and right to cancel, the default period is 15 days, and it's measured after, as opposed to using the word from, to eliminate that confusion we were talking about earlier. Additionally, it removed the word immediately from the seller's requirement to return the deposit. I don't think it's carte blanche for the seller to keep the deposit for several years and invest it in the stock market or anything crazy like that. But the immediately created some problems, just in the practical effects of how you get money from person A to person B. The deposit's still returned to the buyer, but the idea here is to avoid unrealistic expectations that may come along with the immediately requirement. And one situation that may be familiar to you is that if you, as a broker, held the deposit, you would still need consent from all parties prior to releasing the funds, so that's not always going to be immediate. Standard X clarifies that the waiver applies to physical defects. The waiver was never intended to cover something that's a title defect. And sometimes it might get a little bit confusing. Here's a scenario that I think at least some of you are familiar with. Property has fences, appear to be fences surrounding and defining the lot line of the property, and the fences are not on the line. They're a foot over on the neighbor's property, or the neighbor's patio encroaches somewhere. That's, while sort of physical in nature, that's observed physically, that's a title defect issue and not a property inspection issue. And of course, title defects have a different set of rules that applies in the as-is contract as to the seller's obligation to try and resolve the defect, buyer's right to extend the closing date, all of that. And it added the provision that the seller is not relieved of the obligation to comply with Johnson versus Davis, which is found in paragraph 10J, and that the clause is to survive closing. Does everyone know, when I say the case name Johnson versus Davis, what it deals with?
We just had it with Ponemer, but I forgot.
In summary, Johnson versus Davis, and you could look it up and just put that term into Google, and I'm sure you get a hit on the opinion. It's a Florida court opinion that says even in an as-is contract situation where it is incumbent upon the buyer to do his or her inspections and make a decision based solely on the inspections, if the seller knows about a condition or a defect and it's material, the seller is obligated to affirmatively disclose it without being asked by the buyer. And that's, of course, why you go through what I think is a multi-page document. Seller is or is not aware of this, is not aware of that. That's Johnson v. Davis. In other words, if you know about it and it's bad, you got to tell. Don't wait to be asked.
Question.
Yes.
I was always under the impression that the seller disclosure, real property disclosure, was an optional form, not mandatory.
I would agree with that. Yeah, what's mandatory is the disclosure itself, however it's accomplished. But if it's not in writing, that's an invitation for someone to claim it was never made.
So a material defect is required to be disclosed by the seller, even if it's not asked for.
Yes.
Right? Right. Because I'm also told that the largest number of suits against realtors is from the seller's disclosure issues.
And I don't know if that's true or not. And I don't know what's behind that comment, but I can tell you my personal view is using the form and having the seller sign it is going to give you one of the greatest levels of protection, because, I mean, for virtually all of your listings, except maybe your spouse's, you don't know anything about this property. But you'll often be assumed to have knowledge. I had somebody come in this week that was like making all these assumptions about what people must have known. I didn't happen to share the view that they must have known, but when you don't have it in writing, that's what happens. When you've got a comprehensive disclosure prepared by and signed by the seller, you're in a better position to say, whatever your issue is, Mr. or Madam Buyer, it's not me, the broker. Here's your seller disclosure. That goes back to the paper trail. You get everything in writing. Material is anything that would be important to someone who's spending money. Yes.
However, a seller's disclosure is not mandatory.
It is not, you mean the form itself?
The state,
I
yes,
agree
by the
with
state
that.
of Florida, it is not mandatory.
No, I completely agree with that.
I thought that we were going towards making it mandatory, which I thought was a good idea, but apparently it's moving away from making it mandatory. This is just because we were both in Chuck Bonimer's class, and he deals a lot with, court cases that he represents realtors.
Right,
So-
and, but the challenge is that Johnson versus Davis, which is still very good law, imposes the disclosure requirement. So what the form really does is facilitates and documents that the disclosure actually took place.
I'm always suspect in a deal if there is no seller's disclosure. That to me says, okay, what's wrong with it if they don't have something? But you can request it, but it's not mandatory.
In which case you might want to send a written communication that says the fact that we do not have a written seller's disclosure leads me to the conclusion that there is nothing that would need to be disclosed under the Johnson versus Davis standard with respect to this property. Please confirm, or something along those lines.
Yeah.
And then you'll find out or get some more information about whether your suspicions are well-founded or not.
And it's also, I'm suggesting this, that if the seller repairs some of the things in the inspection report, that they annotate it in the seller's disclosure and resubmit it or submit it by email, that they have addressed these issues, if they want to check them to see if they're done to form or whatever, because it's sometimes people do that. They'll get a copy of, the seller will get a copy of the inspection report. The surface is cracked on something or this or that, and they changed it out. If they do change it out at their own will, not obligated by any addendum, then I suggest that it is disclosed in some kind of form.
Mm-hmm. Yeah, I think it's a good idea. Michael, did you have your hand?
I did. I was just wondering if there's any reason why if Greek wants a seller's inspection, when she submits an offer on the property, that she makes it a condition that the seller provides that.
Oh, that's a good idea.
That's a
I
very
never even
good
thought
idea.
of that, but thank you.
That's a very good idea. One of the reasons why I think it's a good idea to belong to this association is because we all get some pretty good ideas from one another, because we've all had different experiences. I like that. Yes, Michael.
I have one more good idea that I've heard in a while.
Michael, I somehow think you have more than one good idea, but
Love you,
I'm
Michael.
biased.
I think we all know that when the buyer has a home inspection done, the liability that the home inspector will admit to only is to the amount of the fee that they charge for their inspection.
Right.
So since we are licensed professionals, if we would happen to make a mistake of going along with that inspector and perhaps appearing to help the inspector, we could become liable as a home inspector, as an inspector for things that the inspector did not find. there was a case where a buyer found things later that were not on the inspection report. They sued the inspector. He was liable for $350. The realtor had gone with them and was pointing out things to inspect, and the court found the real estate broker liable as well, but their liability was not limited to the $350.
What do you mean going along?
If you were physically present, yes, that may increase the possibility that you're going to get included as a target in a lawsuit. I think that the argument in favor of keeping you in or liable for some fault of the inspector is really pretty slim, and I also think that it's just an occupational hazard that at some point in your career, some unhappy party to a real estate transaction whose unhappiness really stems from the behavior of the other party to the transaction is going to want to point a finger at you because of the prevailing attitude in the legal community that you throw a big dragnet over anybody who could possibly have pockets deep enough to pay some money. I would not personally avoid going on the inspection because of that relatively small risk. I'm going to tell you about a recent case that I'd be interested in hearing from you, but also to kind of illustrate a point. Circumstance is it's a wood house on piers, however high off the ground, 2-3 feet. It's got framed lattice work in between the piers, really for cosmetic purposes, surrounding the house. Home inspector is asked to do a comprehensive home inspection. And on one side of the house, there is latches where you can open the lattice work and just take it out, no effort at all. And while, yes, you'd probably have to get down on your hands and knees and crawl, you could get access. And there was a rotten beam, or something as bad as a rotten beam, about this far in, 10 or 12 feet underneath the house. The inspector didn't open the screen and didn't go under the house, and the buyer was very unpleasantly surprised with what it's going to cost to jack the house up, shore everything up, take that beam out, and put a good one in. And the inspector, as you might imagine, I'm on the buyer's side of this dispute. The inspector relies on that provision in the professional standards that an inspector is not required to look at anything that's not reasonably accessible. You think it was reasonably accessible? I kind of agree. I think it was. But one of the things, here's why I'm inspired to say it, Michael. I think that if you were present with that inspector and having had all the experience you've had here in the Florida Keys, you might have been inspired to see those latches and go, you know what, that's no trouble to open this up. Could you just go under there and make sure we're in good shape? Because, I wouldn't be involved if that had happened.
I think that because I learned this from Michael, and I remember this, and he taught me this through that analogy. If you suggest to an inspector to do something, or that you know something about the property, you are acting as an inspector, and that's when you put yourself up for liability. So it's good to be there and listen to see what the inspector says and impart it to your client, but you should not get involved in the inspection itself.
That's, again, for me, one of those fact-specific situations where I think that that may well be a very good idea. But the other side of that is, and I'm sorry, the sad news is I don't like to bash other lawyers, but we do have a tendency in the legal community, if someone comes and says, boy, I want a pound of flesh from someone, we're kind of obligated to go find someone to get it from. And you're a pretty ripe target if you represented either of the parties. If you have knowledge about something that would be sufficient to otherwise inspire you to say, hey, inspector, take a look at this, and you withhold that because you don't want to be labeled the inspector and therefore have the liability that goes along with that, I'm concerned that you yourself would have a Johnson versus Davis problem, that you had knowledge of something and you didn't disclose it, to somebody in the transaction who have done something about it. And it may well depend on what the knowledge is.
I would disclose it if I had an inkling. I would tell the buyer or the seller, but I don't think I would tell the inspector, because then he uses that to exonerate himself.
But if you're using an inspector, to, excuse me, doesn't get his lazy ass underneath something that's more than like scrunch, they can't get under there physically, and or they don't have a camera to look underneath it, that's a quarter of the inspection right there, all that stuff that's underneath the pipes, whether it's, you know, cast iron pipes or PVC or whatever. So if you're having somebody that has that big of a lattice thing and it has latches and they're not getting under there, what kind of an inspector is?
Oh yeah, listen, I agree. I think the inspector fell short on that. That's my personal view, you know. But
and that's why they also have E&O insurance.
Right. Yeah, I understand the dilemma. I don't know that there's a bright line rule, although if you pay attention to doing your job meticulously, I think you can legitimately rely on the others in the transaction to do theirs. You know, I think it's a good idea for you, if you're representing a buyer, to take a look at exceptions in a title policy. I know, pretty dull. You know, a lot of them don't make a lot of sense, even to those of us really familiar with them. But nobody else reads that. And so if you read through it and say, oh, by the way, you know, I'll pick a really easy one. This is in Hark. It's in the historic area. If you want to do anything on the outside, you're going to have to go through this process. There's a host of problems that you can avoid later if you disclose what you know to appropriate people. And that, to me, always means someone who would care about it or someone who can do something about it. Okay. That's it on the as-is contract. It's otherwise just like the regular one. We're going to talk about the rider and some changes on the comprehensive rider, and I'm certain I can get us out of here by 12 o'clock and still cover it. Yes, sir.
Just before we get off both the as-is and the FAR 2, is on this personal property, page 1 of both contracts, line 16 on the as-is, personal property.
Yep.
For some reason they changed that, be that as it may, maybe they were on drugs, but I see this as being a possible real problem for the other, you know, 270 agents who aren't sitting in the room today. What we're saying is that
16.
Line 16, personal property, you now have to list. They're telling you what's in the house, and if it's not in the house, you have to list it on the first line that says these items also are included. So there's no washer, dryer, or microwave. That'd be standard. It has to go on the first line where it says items included. But on the excluded, you'd have to put such things as disposal or intercom or blinds or...
well, let me correct you on one thing about that. The first one, I agree that what you need to do is become very familiar with this phrase that starts with range ovens and goes through refrigerators, dishwashers, disposal, ceiling fan, etc., all the way to the point where it says personal property in quotes with a capital P on both personal and property. And what you have to say is, all these things are present, and therefore I need to do nothing with regard to the first blank space, because, the second blank space. What's excluded under E is something that's in that comprehensive list, but is not physically on the property and won't be conveyed with the property. And then conversely, if there's something on the property that's going to convey, maybe there's an air purifier. I don't think air purifier is on there. You'd want to put down in paragraph D, the items include the air purifier. But, you know, this is one of those that, because we've now got this very comprehensive default list, and I can certainly imagine plenty of homes that don't have all of these or that they're not going to convey, but, you know, it's all just sort of in this blank part where you're not going to look at it unless you make the effort to do it. That's a really important one. The default could get you in trouble.
So all of those checkmark items are no more part of our contract, and we've only got 2 little lines to write: pool equipment, pool heater, spa, storage shed, TV.
Right.
Yeah.
Yeah, and if you need more room, write an addendum. I'll tell you one more war story quickly. My first real estate dispute situation, when I first arrived here in the early 1990s, was at least one person here in the room is smiling, and I know why, is this really great house with incredibly lush, gorgeous, dense landscaping. And the buyer shows up for the walkthrough just before closing, and the landscaping's gone. It's not there. Because it was so lush, it covered up the fact that it was all in pots, on shelves, and it all looked like it was a garden, but in fact it was personal property in a pot, and it made a big difference to this buyer. So, my point in telling that story is, you sometimes have to think pretty creatively about what's personal property and what's a fixture to the real estate. And even the best efforts of the most careful professionals, there may be a situation where something comes up that you couldn't have anticipated. Yes?
I just wanted to check. So on the list here, if the home does not have a refrigerator or a stove, can we scratch that out there?
You could scratch it out, but I would still write it in under E where it says the following items are excluded. I think that would be the better practice. And to follow on from my example, even though potted plants wouldn't, appear to be logical, that may be something, if we had another situation like the one I described, that you'd want to put it in, if the buyer really wanted it, to put it in as property that's included because it's not part of the list.
Sorry. As I'm reading this, it says the following items which are owned by seller and existing on the property as of the date of the initial offer. To me, that's like you saw them, they're there. So if you didn't see them, they weren't there. So we have to physically type in that it's all these items that
what you need to do is you need to determine independently whether all these items on this list are on the property, because what that language means is, irrespective of whether the buyer actually observed these items, the contract is dictating that they're there, whether they are or not. And if you don't modify that, and any of those items aren't there, that can create a significant problem.
I'm just going to say that I don't like this section.
And what they did here was they tried to correct the problems that came up with the checkoff. I personally liked the checkoff boxes better. I should apologize to Ed. I keep smacking my microphone. Sorry about that.
If there's no refrigerator on the property when they make the offer, you don't have to exclude the refrigerator.
Yes, you do.
You still do.
If it's existing on the property. It's not existing on the property. There's no refrigerator.
It says, hold on.
I've never seen a refrigerator.
It's not saying that this clause only applies if it's in fact present. This clause says they are present. And that's how it would be interpreted unless you exclude it. It says, unless excluded under paragraph 1E or other terms of the contract, the following items which are owned by the seller and existing on the property. And I am fairly confident that any decision maker would read that to say that the seller has certified those two things. The list is complete, they're all there, existing on the property, and they're owned by the seller. And I don't think it would be read to say, oh no, if it wasn't existing or the seller didn't own it, then this list is meaningless.
So if you have a short sale where they've cleaned out all the appliances,
you need to X all this out and write in all those things on the what's excluded.
And also submit the listing, the show sheet, the MLS show sheet. And when you went under contract, it says it has all that stuff. You know how it gives all the information?
Yeah, I do know that, and that's helpful in terms of paperwork, but a rule that you all is really important to understand. There's a doctrine in the law called merger, and that doctrine says that all representations and all communications between the buyer and the seller leading up to the contract are deemed to be merged into the contract, and if it's not in the contract, that's the only document we look at. That's why I said earlier that if something gets into a problem, the decision maker is going to say, buyer, seller, be quiet. We don't want to hear from you. We're going to look at the agreement. If we think we can determine what you agreed to, whether you today agree that that's what you agreed to, that's what's going to apply. And the MLS, it's not going to trump this. And I see this, I understand why there are sentiments not liking it. I see this as a real potential problem. And as we all know, what often happens is the fact that a washing machine is missing, and what's that, $1,000, can be used for a pretense to say, I'm not doing this, or I want this. I mean, it's just, it's an area that's worth focusing on and giving careful attention to.
One thing that I sometimes put in is, as per MLS, on this date at this time.
You can do that, and if you do that, then I would recommend you take the printout and you attach it. And when you have your parties initial it, have them initial that too. Yes, yeah, I'm sorry, I cut you off earlier.
Why warranty that the stuff that's on the property is actually working? Because I've had a situation
I believe so.
Between the date of the contract and after, before we close, the stuff stops working. Now, in that particular instance, the seller replaced the item, but I know that, like, we sometimes buy bank-owned property.
Yeah, I know.
On that, they say it's as is whereas, but whatever you get is what you get. But if you have a regular, normal negotiated sale, buyer and seller, you're assuming that things actually function.
I can imagine a number of scenarios. And again, I think there'd be some fact-specific qualifications to what I'm about to say. But I think that generally speaking, that if there's a piece of personal property that's going to convey and it's not operational and anybody knows that, get it in writing. On the other hand, I think that if the refrigerator worked fine on the day of closing and it blew apart 2 days later, I don't think the seller has made a warranty that it would be anything other than a refrigerator that blew up 48 hours after closing. I think that's how that would, generally speaking, that would probably shake out.
But I'm talking the date of contract and the date of closing.
I think that on the date of closing, it needs to be in the condition it was in on the day that the initial offer was made. So if the refrigerator worked on that day and it doesn't work on the closing date, I think the seller has a problem. Yes?
As to this list that was taken out, when you do forms, you can go in there and we put in, our name, our company name as a default that happens every time you pull up that form. Just go in there and list these things and leave it to yourself to take out. I think it might be an easier way to resolve this issue.
Right, your packages, you mean you create packages.
Yeah.
I agree. But however you do it, it's something worth paying attention to, and it's often you're inspired not to. Especially if you're talking about higher end properties, you're kind of naturally inclined to think that the refrigerator's not a big deal, but it can turn into one. The comprehensive rider. It's now called CR2. Its revision date is 8/13. Condominium has been renamed the condominium rider. Paragraphs 1 and 2C have default provisions for number of days for the buyer to be approved prior to closing by the association, for the seller to initiate the approval process, and for the party to sign documents to give those with first rights of refusal an opportunity to exercise. I would take a look at those changes, again, on the red line version of the comprehensive rider and look at them pretty carefully. I'm going to kind of rush through a couple of things because I want to make sure that I cover the things that I think are critical. Paragraph 3A has some new check boxes to indicate whether the condominium assessments or rent payments on recreation areas are to be made quarterly, semi-annually, and annually, in addition to monthly. Monthly was the only option the rider previously provided for. And a new line was added to use to describe a second condo assessment in the event there is more than one condo. But note this additional description is not intended to be used for a homeowners association fee. So, for example, I think Truman Annex, Harbor Place, you know, there's I think it's monthly in Harbor Place, the assessments that are paid to the Harbor Place Condominium Association, and then there's a quarterly or semi-annually assessment that goes to TAMPOA, the Master Property Owners Association. And my point here is the new the new line added to describe a second condo association was not necessarily intended to disclose this, but I think you want to make sure that a buyer knows what they're getting into. If you're in one of those communities where you have either more than one condo association for some reason, or you have a master property owners or homeowners. Yes. Yes. And not rely on this line, is the point. Yeah. And new language was added at the end of fees and assessments that Rider B, the HOA community disclosure, will contain further information about the additional assessments. And Rider B, the homeowners association, has some new language. It's intended to clarify that if the parties have initialed the HOA disclosure, the homeowners association disclosure, that it was provided to the buyer prior to the buyer's execution of the contract for sale. In other words, they got that set of documents that tell them what all the rules are and restrictions with regard to that association. If that's not the case, you want to provide the form to the buyer and obtain the buyer's signature at the bottom of the form. You want to absolutely make sure there's a condo association or a homeowners association that you have it documented that the buyer got the documents or had the opportunity to review them. Rider C, seller financing, added some language and a blank line to describe the term of a mortgage. The default is 30 years for seller financing. That seems significant to me because most seller financing I'm familiar with is usually something like 30-year amortization, 5-year balloon, or something like that. So again, don't leave any blank line not addressed in the form. Rider E, FHA, VA, probably fairly unusual here. But I've seen them for an FHA loan. A default of $250 was added to paragraph 2A to describe a cap on the appraisal repairs, and the words purchase price were substituted for the blank line in that paragraph. 3, hold on, this one is, I need to look at it just to make sure I tell you this correctly. Rider E. FG. No, that's it. Just that it puts a cap or an assumed value of $250 if you don't fill in the cap on that contingency. Rider F, appraisal contingency. It adds the buyer's obligation to deliver a copy of the appraisal and not just notice of it to the seller. If the buyer chooses to terminate because the appraisal is less than the applicable amount in the contract, buyer's got to give a copy of the appraisal to the seller. Won't work to just send an email that says, I got an appraisal that says. Rider G, short sale approval, paragraph 4. Now, if a seller does not deliver seller's accepted short sale approval, instead of just a simple notice that the seller obtained an approval, by the short sale approval deadline, either party can cancel the contract. So, if the seller gets an accepted short sale approval, the seller needs to deliver that by the deadline or run the risk that the contract can be canceled. Sets out a new formula for the contract expiration date. It's 30 days after the expiration, including extensions of the short sale approval deadline. Accordingly, anytime the short sale approval deadline is extended, the contract expiration date will also automatically be extended. And then next, the idea is to prevent the contract expiration date from occurring prior to the short sale approval. Paragraph 5. will change the calculation of contract expiration date from the effective date to commencing from the date of the buyer's receipt of short sale approval. Read it carefully. What it's intended to accommodate is the reality that we're probably all pretty familiar with, that short sales can take a horrendously long period of time to get through the process of approval, and there's kind of a bias in favor of not allowing that to put the parties in a squeeze between the expiration date and the approval date. So hopefully it'll help. I don't know. Yes?
The short sale approval letter comes from the lender, the two lenders, whatever we approve based on this amount of money net, whatever, all the other terms of the thing. Does the seller have to sign that letter to present it to the buyer? Or can he just give that letter to the buyer? What's the effective date of that transaction? You know what I'm saying?
I presume there would be a date that there'll be a couple of dates involved. The date the lender signed the approval, the date that was delivered to the seller, and the date the seller then delivered it to the buyer. So with that in mind, I'm not sure I understand your question.
Does the seller have to physically sign that letter?
No, the seller does not have to sign it. Just that only the lender does. Yes.
I've mentioned this several times, and I haven't seen it really in too many other realtors. In the additional terms, I suggest everybody put in that local appraiser license with address in Monroe County be used, because especially in cases where it's an REO, if it's a finance deal, they'll use anybody out of the state, they'll use it out of Key West, they'll use Naples, all over the cheapest.
They'll go to, what's it called, Trulia? What's the one you can go to?
They'll use any
Zillow.
cheap appraiser that they can get involved. So if you don't put that in your contract in some form, in some additional term, you have a higher percentage of the contract tanking. Yes, you can dictate. You can put it in as an additional term, and you can fight appraisals by using the use pack. If they have to be competent with knowledge, and because Old Town's different from New Town, which is different from Stock Island, which is different from anything else. If you put it in your contract, whether I'm the listing agent or I'm the seller's agent, I insist on it being somewhere in the contract. So they can't use that to tank a deal.
Well, and with that said, here's the biggest challenge that covers virtually every aspect of a short sale. The lender is an interested party who's got virtually all the control, and the lender is not a party to the contract. So you can write in all you want about in the contract, but if the lender says, I didn't sign this contract, that's not my deal, I'll use whoever I want and I'll rely on whatever I want, at the end of the day, the lender would prevail in that fight. However, I agree with you that if you put it in the agreement, you've got a better chance of at least persuading the lender, and this has happened to me on a number of them, that their appraisal isn't truly reflective of either the actual condition of the property or conditions that prevail here in Monroe County that don't in New Jersey or wherever their appraiser was. Okay, rider H, homeowners and flood insurance. It added the word flood to the title. It also added a new subparagraph B to make the buyer's offer contingent on the buyer obtaining flood insurance coverage, and a price not to exceed cap, and the date inserted in the contract. If this is used, it would be in addition to the rights set forth in paragraph D that we had talked about before. Rider I, used to be FERPTA, now it's blank. Rider K, as is. Clarified waiver defects applies to physical defects. Again, was never intended to cover title defects. Rider P, the lead-based paint disclosure, reverse the place for listing the licensee and the selling licensee to sign, but otherwise was unchanged. And that's my summary of all of these changes. And we have 5 minutes to spare for questions if you have some.
Great job.
Thank you.